This trial is a culmination of decisions made by one person, the defendant. Those decisions have forever altered the futures of 3 families, and of you also, Mackenzie. And your decisions forever robbed Dominic and Davion of the futures that they had before them. If there is one thing that can be taken away from this case, as painful as it is this. Every decision we make is important. Every action we make is important. Regardless of whether the decision is a good one or a bad one, or the actions are good or not, the result is the same. The consequences ripple through time and affect many more people than one might think at the time of the decision. In criminal cases, the state carries the greatest burden under our law, proof beyond a reasonable doubt. As I previously stated, I considered all the evidence presented, and at this point I would like to comment specifically on Exhibit 802, the crash video.
This is the kind of case that makes your stomach drop. One decision, one morning drive, and 2 lives gone forever. The judge opens with words that hit like a hammer. This was not reckless driving. This was murder. The defendant, Mackenzie Shirilla, faces a long list of brutal charges. But before we dive into the legal maze, let's make one thing clear. This isn't just about the law. This is about intention, pain, and the ripple effect of a single horrific act. So, buckle up. The courtroom is about to deliver more than justice. It's delivering a reckoning.
This is the type of evidence you can never unsee. You can never forget the visual or audio of this exhibit. It is chilling and tragic. As you review that exhibit, you know that you are watching the oncoming deaths of 2 people, and there is nothing that will stop it. The video clearly shows the purpose and intent of the defendant. She chose a course of death and destruction that day. Exhibit 802 crystallizes the deadly decision-making of the defendant. She morphs from a responsible driver to literal hell on wheels as she makes her way down the street. Mackenzie alone made the decision to drive the car, to drive an obscure route, a route she visited a few days before, and a route not routinely taken by her. Mackenzie alone chose the time to make the drive, early in the morning, when any reasonable person would expect that few people would be nearby to witness it or offer life-saving assistance.
When the judge begins talking about Exhibit 802, the crash video, you can feel the energy shift. This isn't just evidence. It's trauma captured on camera. The judge says it's the kind of thing you can never unsee. And you know what? She's right. If you've ever doubted how powerful video evidence can be, this is it. The defendant's intent is chillingly clear. No hesitation, no panic, just destruction. Let us know in the comments. Should footage this graphic even be allowed in court? Or is it necessary for true justice?
She made these decisions despite knowing, as any reasonable person would, that her mission of death could have involved others, not even in the car with her. Other people, other cars, pedestrians. She had a mission and she executed it with precision. The mission was death. Mackenzie alone decided to push the pedal to the floor and demand the ultimate speed of that vehicle to 90 to 100 miles per hour. She alone decided what was to be. Mackenzie decided death was the ultimate goal that day, and she alone made that decision for Dominic and Davion, and she continuously acted in a manner to achieve her purpose. Whether or not she intended to also kill herself is a matter of speculation. They have no relevance to the weighing of the evidence in this case.
Mackenzie didn't just go on a drive. According to the judge, she mapped the route days earlier. She knew it was isolated. She knew help wouldn't be nearby. This wasn't a heat-of-the-moment crime. It was cold, calculated, and planned. Think about that. Early morning hours, no witnesses, pedal to the floor. The court called it a mission of death. That line alone should haunt every viewer. This wasn't just a crash. It was a decision, again and again and again.
The totality of the evidence clearly demonstrates that Mackenzie Shirilla acted purposely and intentionally in the early morning hours of July 31st, 2022. Her purpose was to kill Dominic Russo and Davion Flanagan. No reasonable fact finder could view the totality of this evidence in this case and come to any other conclusion. Her actions were controlled, methodical, deliberate, intentional, and purposeful. This was not reckless driving. This was murder. Court renders the following verdicts. Count 1. The court, having had count 1 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.02a, is charged in count 1. Count 2. The court, having had count 2 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit, Davion Flanagan, in violation of Ohio Revised Code Section 2903.02a, is charged in count 2 of the indictment.
The language the judge uses here is surgical, controlled, methodical, deliberate, intentional. This isn't courtroom drama. It's a blueprint of how prosecutors paint a murder with words. And it works. Every statement stacks the case higher. She wasn't reckless. She was purposeful. And that purpose killed Dominic and Davion. If you ever wonder what separates manslaughter from murder, this is your masterclass. Comment below. Do you think she truly wanted to die too? Or was it always about them?
Count 3, murder. The court, having had count 3 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.02b, as charged in count 3. Count 4, murder. The court, having had count 4 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.02b, is charged in count 4. Count 5, felonious assault. The court, having had count 5 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.11 of the Revised Code, is charged in count 5 of the indictment. Count 6, felonious assault. The court, having had count 6 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.11a2, is charged in count 6. Count 7, felonious assault. The court, having had count 7 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit, Davion Flanagan, in violation of Ohio Revised Code Section 2903.11a1, as charged in count 7. Count 8.
Now the verdicts start rolling in, count after count. Murder, assault, drug possession, criminal tools. It's a legal avalanche. And it doesn't stop. What's powerful here is the judge's pacing. No drama, no fluff, just hard truth. This is a law doing what it was designed to do. Hold someone accountable fully. Each charge confirms how deliberate this was. And yet, how do you sentence someone so young for something so dark?
Felonious assault. The court, having had count 8 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit, Davion Flanagan, in violation of Ohio Revised Code Section 2903.11a2, as charged in count 8. Count 9, aggravated vehicular homicide. The court, having had count 9 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.06a2a, is charged in count 9. Count 10, aggravated vehicular homicide. The court, having had count 10 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit, Davion Flanagan, in violation of Ohio Revised Code Section 2903.06a2a, is charged in count 10. Count 11, drug possession. The court, having had count 11 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of drug possession in violation of Ohio Revised Code Section 2925.11a, as charged in count 11. Count 12, possessing criminal tools. The court, having had count 12 tried to have pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of possessing criminal tools in violation of Ohio Revised Code Section 2923.24a as charged in count 12.
What stands out in count 10 is the aggravated vehicular homicide. It's not just about speeding. It's about the conscious disregard for life. Mackenzie didn't just risk lives. She made the decision to take them. We often hear about accidents on the road, but the court made one thing clear. This was not an accident. This was a calculated act cloaked in the illusion of a crash. One decision. One morning. 2 lives erased.
The court, having had count 12 tried to have pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of possessing criminal tools and further finds the defendant did intend to use a substance, device, instrument, or article, to wit, a digital scale, to commit the offense of a felony. Sentencing will be 1 week from today, August 21st at 1 p.m. If any party wishes to file a sentencing memorandum, it is to be filed by 4 p.m. on Thursday, August 17th. Thank you.
Thank you. Love you, baby.
By the time we get to the drug possession and criminal tools, you start to see the full picture of her life unraveling. A digital scale. Intent to commit felonies. This wasn't just a one-time event. It was a lifestyle spiraling out of control. The court finds she meant to use these tools to further her crimes. That detail? It flips the story from tragedy to pattern. This wasn't a fluke. This was who she had become.
Everybody drinks this,
The courtroom doesn't lie, and neither do the facts. Mackenzie Shirilla has been found guilty on all major counts, including murder and aggravated vehicular homicide. 2 lives gone, 1 life shattered, and a community left to pick up the pieces. What this case teaches us is simple. Every decision matters. And sometimes, the smallest ones have the deadliest consequences. If this breakdown gave you chills, hit that like button, comment your thoughts below, and subscribe for more No BS Courtroom commentary. Justice doesn't whisper, it roars. And we'll be here to cover every echo.